If you've been sued by a debt collector, you might be wondering, what does the debt lawsuit process look like? And in today's video, I interview a real attorney, Sarah Wolk, about this question. We go over how the debt collection lawsuit process looks and what to expect if you've been sued by a debt collector. You might be feeling scared, intimidated, maybe even a little bit hopeless if you have been sued for debt. And I hope that this video gives you some insights into your options if you have been sued, and helps you find answers to questions like, how do I respond to a lawsuit? How do I settle a lawsuit? And more. Thanks so much for watching, and here's an attorney's take on what the debt collection lawsuit process looks like and how to resolve your debts.
What is the typical process of a debt lawsuit? What does that look like?
Okay, so a debt lawsuit is going to be similar to other civil lawsuits. If you've been involved in one of those, the general process is going to be very similar, most likely. Basically, you're going to have at least two parties. You're going to have a plaintiff and a defendant. The plaintiff is the party that initiates the lawsuit, files it, and is suing the defendant. In the case of a debt lawsuit, that's usually going to be a debtor and a creditor. So the creditor is the plaintiff, the person that is owed something, usually money, and the debtor is the party or the person that owes the money to the creditor. So to start the lawsuit, the plaintiff or creditor files a complaint and a summons. Once that's filed with the court, they get it back stamped, so it's an official document, then it's public record. And then they have to actually serve it on the debtor. If it's not served, the debtor has no obligation. And it's still a lawsuit, but the debtor doesn't actually have to respond or do anything. There can't be a judgment that's issued. There are also requirements for how the summons and complaint have to be served. Generally speaking, that's going to be personal service, meaning it's given to the actual defendant. So if you're being served, you want to kind of make sure that you're properly served, because if you're not, again, you don't have an obligation to actually respond or do anything. However, once you are served, that is what triggers the time for you to respond to the lawsuit. Now, there's different kinds of responses, but if you fail to respond, the other side, the plaintiff, is going to most likely request a default against you. If a default is entered, you can no longer participate in the case. So basically, the court isn't going to listen to anything you have to say anymore. This generally means that it's going to be easier for the creditor to actually get a judgment against you. They still have to present evidence to the court to show their case, but there's going to be no one able to argue against it because you can't participate. So generally speaking, cases when there's a default are going to go to a judgment. So you want to try and respond if possible, and a response can come in different forms. An answer is a very common way to respond to a complaint in a lawsuit, but there are different motions, like a motion to compel arbitration, that you can file as well. So you can consider different things. So then you kind of get to the middle of a case, and in the middle of the case, there's going to be sort of two different things going on. One is basically things that involve the court, and the other is things that don't involve the court. Things that involve the court are going to be things like hearings. There's almost always a hearing called a case management conference or trial setting conference. This is basically a status conference where the judge is going to want to find out what's going on with the case, kind of how the case is proceeding, when it's going to be ready for trial. If the judge doesn't think it's far enough along, that hearing could be continued. If the judge thinks it's a good time to set trial, then you'll get a trial date at that hearing. So that's something to look out for, because generally speaking, the date of that hearing is going to be in the initial paperwork that you're served with. So with the summons and complaint, you're going to get a service packet, or you should get a service packet. And there's going to be a lot of information in there, and it's probably overwhelming, but you really want to read through it, because it's going to give you most likely this court date and a lot of other information, things that you have to do before the court date, which include like meeting and conferring, talking to the other side, filing a case management statement. So you want to read through all of that. In addition to that basic hearing and other similar ones like status conferences, there can be motion hearings. And that's basically when there's a dispute between the parties that can't be resolved without court intervention. So then you go to the judge and ask for assistance. Now, the other side of that is the things that don't involve the court. So there's a lot of things that happen in a case that are kind of informal. You don't actually go to the courtroom. You're just talking to the other side, talking to the other attorney. And the main thing that's going to happen in most cases is called discovery. And discovery is basically when you're finding out what the other side has, how they're going to make their case, and how they're going to present it. You can also talk to the other side about settlement informally. And you can also talk to other parties like witnesses, possible witnesses, to try and find out what information they have and maybe help support your case. So those are going to be things that are going to kind of happen during the middle of the case. Now, I mentioned settlement already. You can talk about settlement at any point in a case. You can settle informally, but the court also usually encourages settlement, and in doing so, they will set some sort of mandatory settlement conference frequently, and sometimes encourage the parties to do some sort of other mediation. Now, the parties always have, and when I say parties, I mean the people involved in the lawsuit, the companies involved in the lawsuit, the plaintiff and the defendant. So if the court sets a settlement conference, you're going to attend the settlement conference. You have no obligation to settle, but you have to participate in good faith, basically. You can also go to private mediation. Private mediation can be good because the mediators generally spend a little bit more time on the case, but it also costs money. You pay the mediator to do this, whereas the court settlement conferences are free. And then if the case does not settle, then at some point you get to trial. And trial can be before a judge or a judge and a jury. And what you do to prepare for that is going to differ between the two. So you want to make sure you know if you're going before just a judge or a judge and a jury. And you also want to make sure that you, again, read all the paperwork you get from the court, whether it's at the beginning of the case or at one of the hearings with the judge. Because a lot of times the courtroom itself will have some specific rules that you have to follow for things that you file with the court before trial. And when I say file things with the court, I mean you actually submit them to the court so they become an official record and the judge actually sees them at that point. So I think that covers the general process. Any other questions about that?
No, I don't think that I have any other questions, but just to give a little recap, there's a lot of different routes that a debt lawsuit can take, but typically I think like the most common routes would be, the plaintiff or the debt collector or creditor, they file the summons and complaint. And then if you don't respond in time, you either lose automatically by default, or if you do respond in time, the case could move forward, whether it's going into some sort of a case trial setting where you have to show up and you might, meet with the plaintiff face-to-face and have to settle face-to-face, right? Or it could move into discovery, which is where you said, like, you kind of are gathering your documentation and your evidence to try to present your case to the court, right? But there's lots of different, I guess, routes that a debt collection case can take. We actually have a flow chart solo suit that details it. I'll show it on the video right now, but it kind of just goes over a bunch of different routes that your case could potentially take. But it really just depends on the specifics of your case and the factors of your debt. Were you going to say something though, Sarah?
Yeah, I was going to clarify a couple of things if it's okay. One is that if you have a default entered against you, you don't automatically lose. It's just generally you're going to lose and you can't actually do anything to prevent the other side from getting a judgment. But the other side still has to actually present things to court. So it's not literally automatic. I just want to clarify that. And then settlement and discovery can be happening at the same time in a case as well. They're not really like separate things that happen. And the timing of them, like discovery pretty much starts right after, sometimes very soon after a party is served. And settlement usually is a little bit later on, but discovery is usually still going on.
Gotcha. Thank you for those clarifications. I think the main takeaway though from everything you just said is like, the best thing to do when you have been sued for debt in most cases is to file a response, because if you don't do anything, you do risk that default judgment, which makes it harder for you to defend yourself. So I think that's like that first step is to file an answer. And at Solo Suit, we can help people create an answer that's customized to their case and just get that filed in. And then they can decide where to go from there, whether it's hiring an attorney or trying to settle the debt, right? But yeah, thank you for those clarifications.
I really hope that this video was useful, and if you've been sued for debt, I hope you know you're not alone. Solo Suit is rooting for you, and that is why we share conversations like the one I just had with Sarah. It's to help individuals know how to resolve disputes and resolve debts. So if you have any other questions or you want more information, please reach out to us at support@solosuit.com or check out our website. As always, thanks so much for watching and good luck with resolving your case.